Can you still make a claim if you signed a release? Hi, I'm Frank Nunes. I'm a California personal injury trial attorney practicing in the state of California. Join me as we discuss some of the issues involved in this question. Normally when you do something that's extremely dangerous, like riding a mechanical bull or going to a trampoline shop, they'll have you sign a release at the beginning. The release may or may not be enforceable. First, you have to look at the release to see if it has more than one meaning. Is it capable of being interpreted different ways by different people? If so, it might not be a valid release. You usually use evidence on the face of the document itself, or at times you can use outside information to determine whether the terms of the release are in fact valid. The release has to pertain to an injury-producing event. In at least one case, a gentleman signed a release to go into the pits of a race car track. He subsequently was sitting in the bleachers fell down on him, and they said, you can't sue us, you signed a release. No, because that wasn't the purpose of the release he signed. The purpose of the release was to prevent him from bringing a lawsuit for any harms inside the pits of the racetrack, not for the negligence of the bleachers falling down, which he had nothing to do with it. There are also other limitations on the release. You can't release gross or excessive negligence. So if somebody is doing something that's beyond negligent and just completely reckless, you can't sign a release to be absolved of suing the person for that conduct. And releases that are against public policy, sometimes, for example, in child care releases, are not permissible in the contracts themselves. Releases that violate the law are also unenforceable as against public policy. For example, someone says, I give you the permission to shoot me, and I'm going to sign a release that I won't sue you. That is one example where the courts could find that the release violates public policy. Finally, product liability. You get a product, and by buying the product, you impliedly waive that you won't sue anybody if the product is defective or doesn't handle the way it's supposed to handle. Those kind of releases have also been held by courts to be unenforceable and a violation of public policy. So that's a quick explanation on whether you can still make a claim even after you've signed a release. By the way, if you found this video helpful, subscribe to our YouTube channel. Why? So you can continue to get fresh new videos every time we post additional content. And if you have questions, I want you to pick up the phone and call me. I answer questions like this all the time, and I can answer yours. You can reach me at 559-436-0850. I'm Frank Nunes, and thanks for watching.